But I'm looking at the list because we also have some other properties, houses, and even undeveloped land,
Yes.
and some others.
Yes,
making the list.
it's a judicial process where you go over there, but you just have to prove it by, it is just a probable cause thing, standard that say it is more likely than not that this asset is linked to this crime. And once that is proven, that asset is temporarily seized.
Do you think that, I mean, you've practiced in the States and now you're here looking at two legal systems. Do you think we should, because it appears that there's a gap here, should we come up with something like maybe Proceeds of Corruption Act, wherein this kind of scenario you're allowed to name whatever you find and in the circumstance which you find it, and then maybe ultimately when you get conviction you now go the whole hog?
Well, I don't even think you need an act to do that, because I think what we have now regarding that aspect is adequate. How? You just have to distinguish between an accused and a witness, between evidence and recovery. Loot. You see, if you are still in process, you have not convicted the person, that is evidence. You can't even use it, you can't spend it, because that is what you need to now convict the person. Now, if you want to do plea bargaining, you still don't call it recovered loot until the court certify, and you go to court and you say, look, we have reached an agreement, this person is going to plead to this or whatever, and then you let the case go. If the Attorney General does not want to prosecute, that is prosecutorial discretion. Exactly. And whatever it is that you recovered in that process is not looted fund. It's recovery of money that's missing or something. You put it there. But once you call it looted fund, you are attaching it to guilt.
So where we are right now, at this point in time, what would you advise the government to do?
Well, that's my advice right there. Don't go about saying something is looted until you can prove that it is looted. In the interim, if you want to show the public that you are doing a great job of fighting corruption, you can say from witnesses we have recovered this amount of money, pending prosecution of the suspects and accused. Some of them have been voluntarily submitted, and in that regard, the Attorney General may, based on his absolute discretion, which cannot be questioned, bring about a case, or may not, weighing all circumstances of the. Like I said, we started off on the wrong footing by saying we recover looted fund. Maybe it's not even the government that said that. Maybe it's the newspaper that I don't know.
So the government said they were going to name those names.
Yeah, they said it. I read it.
The current government has continued to hammer on the fight against corruption, and this is one of the steps they are taking to show that they're fighting. But there are those who argue that they're going about it practically about the same way other governments have gone about fighting corruption. I mean, especially with this now, you don't name the names and shame them. So would this help in any way in ending corruption or curbing corruption?
It depends on which way you're looking at it. Fighting corruption cannot be done without the judiciary. So if we go about and say, well, the president is going to fight corruption, you have to think of where the judiciary will come in there. Law enforcement must take recognition of the role of the judiciary. So if you go and misrepresent what is going on, or maybe it was not deliberate, maybe it was just the over-enthusiasm of pleasing the public, the thirst for, fight against corruption, that it did that, then you have the responsibility of reversing yourself and correcting it. Otherwise, it's like cutting off the nose to spite the face.
And I asked Mr. Ngige if the government would have done better if they had come up with a tabulated, like a table, the way you highlighted it, say, okay, there's funds recovered, maybe as exhibit that you found in someone's possession, and these are also funds that were willingly returned by some people who felt that the source of that money wasn't really legal, and they decided on their own to say, will return in this. At least it can kind of give them the toga of good citizens of the country. Would that have helped the government?
Absolutely, because at that point you are putting in the distinction and preventing wrong opinion about those you are listing there, because you are now being particular and say this is exhibit, this is evidence, this is what was voluntarily rendered by a witness. If the witness agreed with you for their names to be released, look, when you go to court anyway, you call those witnesses, it's public information. Okay, so witness A, B, C. So a witness cannot now go out and say, well, I'm being liable or whatever. But the government say, I'm just a witness. So you have a defense against those who might call you a thief, you see. And there are so many of them. And I know for a fact that some money were recovered in that way. You know, we read about money being passed to political operatives to do things. Those political operatives out there may not even know the source of that money. And if they come for willingly to surrender the money, you have to give them that right of privacy. One, they are not public officials. And if you push it further and you say, well, are you going to be a witness? And they say, no, then you can use that to kind of bargain whether to release their name or not. But as soon as they bring up for that money, they are connected to that crime one way or the other. They may not be the principal actor, but they are witnesses.
Do you think that at any point in time, we should consider shifting the burden of proof to those who will recover these funds from?
No, that's a big deal. When we shift, and I read it somewhere where somebody complained that, oh, it was a mistake. Some time ago, there was an opinion by the same person to shift the burden of proof. It's a very, very dangerous terrain. You are the accused. The government has all kind of instrumentalities against you. Now, when we label cases here, we say EFCC v something. Where I practice, if it's a federal company, it's US v you. I mean, you are looking at small u against the whole country. So if you say the Federal Republic of Nigeria against Mr. X, it's a big deal because the government has resources to prosecute you. They can go and get witnesses. They can pay for forensics. They can do all those things, which you may not be able to. So shifting the burden on you, it's absolutely wrong. To prove that you're not guilty. I mean, I read it and I was really, really shocked because that was coming from a very, very prominent lawyer. I was like, this is a democracy. You are people under rights. You have rights that must be protected by the government. Part of that right is not to be subject to false accusation or be falsely punished or be treated inhumanly. So it has to go with our rights as human beings.
Oh no, sister, maybe that's why the former president says it. He likes to say Bill of Rights.
Yes, I think in our constitution there are rights there, and I think the former president may be right when we say a Bill of Rights. You see, cases determined, like I mentioned before, when people were against, but they challenged pre-trial forfeiture, they based it on the right, the Sixth Amendment right, that says you have the right to a lawyer of your choice. The government cannot tell you hire A or hire B, to the extent that even if you don't have a lawyer, the government will pay for one for you. So you have your right. Even an accuser, a criminal still have rights to be, I mean, you cannot, there's double jeopardy, there's, unjust sentencing and so on and so forth. But when it comes to issue of recovery, giving back what you have stolen cannot be part of the bargain. Because you stole this one. At the end, when you are sentenced, over there, when you are sentenced for stealing or for corruption or something, part of your punishment is that you pay the money back restoratively. I represented a client who was charged for mortgage fraud. At the end of the day, I mean, we lost the case, and the part of our sentence was for her now to pay back the government $2.something million, which means she will pay that money for the rest of her life. I mean, she didn't have $1 million. But the government said, okay, fine, you don't have it. Just start paying about $45 every month till you die. And then they go after your estate after that. So restoring what is stolen cannot be part of the bargain. You stole it. It's not yours. You have denied people, the government, the public, the use of that money. You must be punished for it. Plus the fact that you must restore the public back to its original position.
Well, now they also say that, Mr. Ngigi was suggesting, look, we shouldn't be in a hurry, because at the end of the day, when these investigations and maybe trial is concluded, the names will eventually be published.
It's all right. Like I said, that's the determination of the government. If the government was not ready to face this controversy, it should not have come out and say, we are going to give you names we're going to show you what has been recovered as looted fund, and we're going to name the looters. So they started off on the wrong hand. They then on the wrong foot. Then I can go back and say, oh, well, look, this has been misunderstood. We recover some money as exhibit. Some are still in the process of forfeiture, and we cannot release these names because some people are still going to be prosecuted. We're investigating, but this is what we recover as exhibit from volunteers, some who are witnesses, and you explain that. The public will understand, rather than say it, looted fund.
The rule of law, always very interesting.
Yes.
Well, Muyiwa Shobo is a legal practitioner. Thank you for coming on this morning.
It's
I will be back in just a moment. Don't go away yet.